day everyone, my name is Janavi Lin Xing with metric number 273158. Today I'm going to present regarding the striking out pleadings which I have prepared in infographic posters, and I would like you go just read through it. Now I'm going to discuss regarding what is striking out pleadings. Striking out pleadings can be found in Order Acting Rule 19's Rules of Court 2012. A party may apply to strike out either the opponent's pleadings, any part of it, or the plaintiff's endorsements on the writ. Endorsements is a short paragraph found in the writ, the form. In that paragraph, plaintiff's court appeal is described. Moving on to who can apply. Who can apply to striking out applications? Well, the answer is both parties, the defendant and plaintiff. Now, let's talk about the defendant. If the defendant is applying for striking out, there is two possible applications, whereby applies to strike out the plaintiff's endorsement on the writ. The plaintiff's action will be dismissed because once endorsement is struck out, there is no more cause of actions. The second one is apply to strike out the plaintiff's statement of claims, either the whole or part of it. If the plaintiff's statement of claim is sufficient, then the plaintiff's actions will proceed. If the plaintiff's statement of claim is insufficient, then the plaintiff's claim will be dismissed. So, if the plaintiff is applying for striking out, there is only one application, whereby it is to apply to strike out the defendant's defense, either the whole or part of it. The court strike out the whole defense, the court will give the judgment to the plaintiff. If the court strike out part of it, the court must ask questions. Is the remainder of the defense is enough to sustain as a defense to the plaintiff's claim? If the answer is yes, the remainder is enough. The case proceeds to the court. If the answer is no, the court will grant the judgment to the plaintiff. Coming to procedures of striking out pleadings, there are four procedures. The first one is when to apply. Applications may be made at any stage of the proceedings at any time. However, this has been qualified by the cases. The second one is the applications to striking out must be made based on three things, and this can be seen in the case of Bank Bhumiputra Malaysia Berhad versus Lauren Azams Osman and others, where the applications to strike out must be made promptly, and applications to strike out must be made without delay, and preferably the actions must be made before the close of pleadings at any stage, for especially 14 days after the delivery of the last proceedings. Also can be seen in the case of Jamil Hassan vs. Kaming, where the party delayed the applications to strike out, affect the party's chance to succeed. The third procedure is leave of the court, by way of notice of applications, and the second one is affidavit, where the affidavit in support must state precisely which ground the applicant is relying to strike out. Under Order Acting Rule 19, on the ground of no reasonable cause of actions of defense, the pleadings are scandalous, frivolous, or vexatious, the pleadings will prejudice, embrace, or delay a fair trial of the actions, and pleadings are otherwise an abuse of the court of actions. Coming to the final procedure is the order sought from the court. The applicants must also state precisely the order which is sought from the court, whether striking out the whole or part of the pleadings. There are four grounds for an application of striking out pleadings and endorsements. The first one is no reasonable cause of actions or defense. Under Order Acting Rule 19(1)(a), it means no cause of actions with some chance of success when only the allegations in the pleadings are considered. No evidence admissible under this link. So this can be seen in the case of Muhammad Azam Suja and others versus United Malayan Banking Corporation Berhad, where the court appeal held that the plaintiff cannot proceed with both prayers for striking off under Order Acting Rule 19(1)(a) and summary judgment under Order 14, so he must choose either one. The court in the case of Taib bin Awan versus Muhammad bin Abdullah, where the court held that an action of malicious prosecution was struck off because the trial was still an appeal stage. There is no cause of action since there is no decision given by the court yet. If the plaintiff's claim barred by limitations, can the defendant apply to strike out under Order Acting Rule 91(a)? So the answer is you are not allowed to apply. to strike out under this order acting Rule 19(1)(a) on the basis that there is no cause of actions. It does not mean that if the limitations has expired, the plaintiff has no cause of actions. It just merely means that the plaintiff's cause of actions is barred by limitations. This can be seen in the case of Ronex Properties Limited versus John Line Construction Limited, whereby it held that the limitations does not remove the cause of actions. It merely bar the remedies. The defendant still can apply under order acting Rule 19(1)(b) or D. So, in the case of Evans versus London Hospital Medical College, the witness enjoyed the immunity as well, so the actions was struck out. The second one is the pleadings are scandalous, frivolous, or vexatious under order acting Rule 19(1)(b). The derogatory remarks or use of abusive language, the pleadings which are considered to be trivial or annoying. For example, res judicata, wrong party is sued, the defense is only bar, denial, limitations has set in. This can be seen in the case of Malayan Banking versus Dang Gong Yen, whereby it was held that the plaintiff succeeded in striking out certain paragraphs of the defense on the ground that it does not have reasonable defense as being frivolous or vexatious. It was held that the case of Patimana versus Kartika Ratna Tahir, whereby it is the duty of the court to act at the earliest opportunity to strike off the offending facts and matters in pleadings, particularly in the present proceedings where the pleadings were ordered by the court. In the case of Richards versus Deputy Public Prosecutor, the Court of Appeal held that it was an open to the court to strike out a statement of claim as disclosing no reasonable cause of actions where the facts alleged fell outside the limitations period, although in certain circumstances a plaintiff might be held to have a reasonable cause of actions, for example, where it could be shown that there might be an escape from the statute of limitations. However, where it was clear that the defendant was going to rely on the statute and there was nothing before the court to suggest that the plaintiff could escape from it, the claim could be struck off. So, the defense is only bar denial without merit and unjustified. The third one is prejudice, embrace or delay the fair trial of the actions under order acting Rule 19(1)(c). If a pleading is unnecessary and tends to prejudice and delay the trial, then it offends the pleadings and does not inform the other party of its case. For instance, this may happen whereby the defendant does not state clearly how much the plaintiff's claim is denied, or the defendant raises issues that are not relevant to the plaintiff's claim. This can be seen in the case of Lim Kuan Yew versus Ching Wing Ken and others, whereby the defendants published 2 articles in Sunday Star in Malaysia, commenting on the suicide of Mr. Tan Cheng Wan, the Minister of National Development in Singapore, and the collapse of the National Bank of Brunei. This article in particularly commented on the effect of these incidents on the image of the Singapore. The court then ruled the general and obvious fact disclosed by the defendant will embarrass the plaintiff and delay the fair trial of this action. The fourth one is otherwise an abuse of the process of the court under order acting Rule 19(1)(d). In the case of Gabriel Peter and partners suing as a firm versus Wee Chong Jing and others, the court held that the term abuse of process of the court under this rule has been given a wide interpretation by the court. It included consideration of public policy and interest of justice. The categories of the conduct rendering a claim of frivolous, vexatious, or an abuse of process are not close and could depend on the relevant circumstances of the case. It must not be used for improper purpose and might be used for genuine and bona fide purposes. It cannot be comments and actions under ulterior motive other than genuine or real purpose. This can be seen in the case of Remington versus Scores. Other than that, the court in the Ansar Techniques Jambahat versus Singles Jambahat dismissed the plaintiff's order supporting summons, and later on the plaintiff applied to wind out the defendant's company irritated by the decision. There was no certifications given by the plaintiff as to the winding up petition, and it was found that the plaintiff's intentions is to embarrass the defendant. In res judicata, you cannot really litigate a matter that already been decided by the court. You cannot really litigate on an issue which already litigated in a previous case, and you cannot really litigate on an issue which could have or should have been raised in the previous case. This can be seen in the case of Superintendent of ABDUL Prisons and others versus Sing King Chun, whereby the plea of res judicata applied in this, and there is moreover the inherent jurisdiction of the court in cases where res judicata is not strictly established and where estoppel per rem judicatum has been sufficiently pleaded or met out. But nevertheless, the circumstances are such as to render any re-adjudications of the question formally adjudicated upon a scandal and an abuse, to enable the court to dismiss the action or stay proceedings or strike out the defense, as the case may require.